Good evening. I'm Jacqui from TBA Law. I'm an accredited wills and estate specialist, and you are here tonight for the Planning for Retirement and Pensions webinar. So, what I'm going to do is flick over my screen so you can see my slides, and there'll be a couple of slides which will be introduction slides, so as people come in they'll then be able to catch up. I won't get into anything too serious for the first 5 minutes or so. Now you'll have a Q&A button down the bottom of your screen, or you'll have a chat box to the side of your screen. So you can put questions in those. Now I won't see your questions because I will be on my slides for most of the session, but I will come back at the end and I'll have a look at your questions. So I'm now going to share my slides. So as I said, the webinar tonight is planning for retirement and pensions. So this is from an estate planning perspective, okay? So I can't give you financial advice. I'm going to talk about minimising assets for a Centrelink test. I'm going to talk about a little bit around the structuring of superannuation. And I'm going to talk about estate planning where there's a beneficiary in your estate, potentially a spouse, who is on a pension, and we don't want to knock them off their pension by getting their inheritance. So those are the three main things that I'm going to be covering tonight. So who am I? So as I said, my name's Jacqui Brauman. TBA Law is my business. I'm the owner and principal solicitor. I am also an accredited specialist. So lawyers do a law degree and then they do a traineeship or articleship to get qualified. And then subsequent to that, I've done a master's degree in wills and estates. And after that, I've done a 12-month program with the Law Institute of Victoria to get accredited. So there's only about 80 of us in Victoria out of about 20,000 lawyers who have the accreditation in wills and estates. But being a lawyer is not the only thing that I do. You can see me here in the evenings. I've obviously got a million books behind me, so I do enjoy reading. But on the screen there, you can see that my husband and my dog were on our boat out on Lake Eildon, so we do a fair bit of fishing, and that's what I do with my weekends. If I can, I get away from the computer and the phone, get out into nature, and even if we don't catch fish, I don't mind because I'm out and away. Although if I'm catching fish, they're usually bigger than my husband's. So I love the estate planning side of wills and estates. So working in wills and estates causes me to work in a lot of deceased estates matters. So after someone passes away, I get the probate and I administer the estate for someone. And sometimes there's litigation involved as well if there's a claim on the estate. I really don't like litigation. I like the planning process while people are still alive to try and avoid litigation. So estate planning has changed a lot over the last 50 years or so. People's lives have gotten far more complex as well. So a will used to be sufficient 50 years ago. It's not sufficient on its own anymore. So in the estate planning process, you can see this little poker chip of all of the aspects that we look at. So we look at property ownership, how you own things, what you own, because how you own things also determines whether it's in your estate or not and who it can transfer to. Wills are important. Enduring powers of attorney are just as important these days because people do not often die suddenly anymore. People have some kind of accident or long period of decline or illness before they pass away. An enduring power of attorney covers people while they're still alive, but after they've lost capability. Same with appointing a medical treatment decision maker. If you're still alive, but you can't make decisions for yourself anymore, you need someone to be able to refuse medical treatment if you want that. An advanced healthcare directive is something that is, or particularly a binding one, has only been introduced in March of 2018. So you can have an advanced healthcare directive which binds your medical practitioners with or without having spoken to the person you've appointed to make medical treatment decisions for you. So that can be a good thing in the case of an emergency. If the doctor is aware of your advanced healthcare directive, they have to follow it. They don't have to speak to someone first. Superannuation is one of our biggest assets these days. So we actually have to tell the super fund who we want our super to go to, because it's not an estate asset. It's not automatically covered by your will. Testamentary trusts are used more and more these days. There are many types of testamentary trust, including life interest, minor trusts, but the main testamentary trust we refer to is a testamentary discretionary trust or testamentary family trust. Same sort of thing. It's like giving your beneficiaries an investment vehicle instead of inheritance directly. Life insurance and TPD insurance is important consideration as well. Instructions to guardians may be important if there are minor children involved. Family trust appointments. So more and more people these days, if they're operating a small business, potentially it's through a family trust, or if there are investment properties, they may be in a family trust. So we have to make sure the family trust control transfers to the right person, because again, the assets in the family trust are not dictated by what the will says. And then there's a few extra things about what you want done with certain personal things, personal items, heirlooms, and what you want done at your funeral. So that is what we look at during the estate planning process. Now, getting into planning for retirement. So I really love when people in their 50s start working with a financial advisor to look towards structuring their assets in readiness for retirement. Particularly farmers, because they often have a lot of land assets. And of course, land is often counted as an asset for Centrelink purposes. So if they have a lot of land in their name, they're not going to qualify for pension. So things to bear in mind for Centrelink. So Centrelink has a gifting rule. There are no gifting taxes anymore. The only gifting rules are Centrelink's rules. So that rule is that you can only give away $30,000 over a 5-year period, or else Centrelink will still count what you've given away, right? So $10,000 for 3 years and then 2 years without anything if you're giving away cash. It's very little amount, really, if you've got large assets that you need to get rid of. Particularly like I was talking about with farmers. So a good example would be a farmer who has a house in town where he lives and owns 3 or 4 titles out of town on which he farms. So this is a 55-year-old farmer. We're starting to plan towards retirement. That land is going to be moved into a family trust. Luckily, farming land can be moved into a family trust without paying stamp duty. So we can offload some of the assets out of his name early enough so that once he is 65, he can apply then for the pension because the land was transferred well and truly over 5 years ago, so it won't be counted. So he gifts it out of his name into the trust. So it breaches the gifting rules. So if he was to try and do it at 63, he'd then have to wait until 68 to be able to get the pension. So bear that in mind if you're trying to offload some assets to qualify under the asset test for Centrelink. Superannuation is something else to plan for with retirement. So obviously, a majority of us are contributing to super. Sorry, little tech glitch. Superannuation. Gotta love tech. So your superannuation, if it's like most people's these days, is an accumulation superannuation. So it means your superannuation is just like a bank account that you're paying into and it's accumulating. Now, once you get to retirement age, you can change that account to a pension account within your super. You don't have to move all of your super out of accumulation. You can have two accounts, so to speak, in your super fund. So you can have your accumulation amount and you can have your pension amount. So superannuation, as I talked about before when we were looking at the poker chip, is slightly different asset to everything else. So you have to nominate on your super fund who you want your beneficiary to be. Now, it's easy when we're dealing with an accumulation account because it's all in the one account. So it gets paid out as a lump sum, accumulation does, if you pass away. So what we do is do a binding nomination form from the super fund, and we tell the super fund who we want that money to go to if you pass away. Now, once you change your superannuation from accumulation to pension, your pension account will need a different nomination on it as well. And the interesting thing about your pension account is that you can nominate your spouse, so only your spouse. However, if you do have children under 18, potentially them as well, you can nominate them to get your pension after you pass away. So it doesn't have to come out as a lump sum. They can get the same amount and essentially have more super of their own. You can't do it with accumulation. Again, accumulation has to come out as a lump sum. But once you are in pension phase, your pension account can revert to a spouse. So bear that in mind. The other thing to bear in mind is that recently the government changed how much you could have in your pension account. It's capped at $1.4 million, which is a hell of a lot of money for most people. But there are people, say, who have 800,000 in super and they have it in their pension phase. Their spouse might also have 800,000 in pension as well. If one of them passes away and they want to revert their pension to the other person, you can see that an extra 800,000 going to the other person in a pension account is going to push them over 1.4. It comes up to 1.6 if they've both got 800,000 in a pension account. So it means that part of that will have to be pulled out as a lump sum. So that's something to bear in mind. So that's superannuation. Estate planning for beneficiaries with pensions. So when we're doing estate planning, we've got to think about who the beneficiaries are going to be. But not only that, we've got to think about the financial circumstances that the beneficiaries are going to find themselves in. So I quite often do a lot of planning for older parents who have adult children who are disabled. So they're the primary carer for their disabled child, and they're worried about what will happen to their child after they pass away. Now, their child's on a disability pension, and we've got to consider that an inheritance from their parents may potentially push them off the pension. So that's one scenario. But the other scenario is also spouses. So same thing could happen. So again, we've got to look at the form in which the person takes their inheritance. We've got to look at the asset test primarily to see what the beneficiary will end up with, to see whether it's going to push them over the pension threshold or not. Now, this is we can only do the best that we can, because the asset test has been changing over the last few years. So we can only do what we can do with the information that we have at the time we do our planning, which is why we do suggest that the planning happen every 3 to 5 years. So yeah, do bear in mind what we can do with pensions. Now, aged pensions are different from a disability pension. So when I was talking before about parents with adult children who are on a disability pension, there's the potential that we can essentially hide their inheritance in what's called a special disability trust. So a special disability trust and whatever assets go into that are not counted for the purpose of the Centrelink asset test, if Centrelink approves it. So that's up to about $460,000 that a person can have. And so they're earning that income, and they've got that potentially to help them with accommodation and, the ability to live, and it's not counted as an asset. So really useful when you're dealing with beneficiaries who might be disabled or on a disability pension. Different all over again when someone is on an aged pension, so that won't apply. So if you try and put assets into a trust, it will still be counted as that person's assets. So I'm just going to quickly flick back to see whether there's any questions. No, nothing in the chat box. Okay. All right. So that is really the things that I wanted to cover off about retirement and estate planning. So Centrelink gifting rule, you have to get rid of your assets at least 5 years before you're applying for a pension. Superannuation, a number of things to consider. That is your binding nominations on your super fund, but also whether leaving a pension to a spouse is going to put them over the cap rule of 1.4 million. And then planning for how your beneficiaries are going to receive their assets. So don't only think about who your assets are going to if you pass away, also think about how it's going to impact them. Look, and potentially, the thing to think about is that if they get a big enough inheritance, the income that they're going to earn off that inheritance is better than the pension anyway, potentially. The problem with having such low interest rates is that potentially it's not. So at the moment, as I'm speaking now in 2019, that's the difficulty that we face, but we may not have that issue in the future. So in terms of estate planning, this pyramid is sort of emotionally how people often go through the process. So they start at the bottom of the pyramid, quite stressed and uncertain. They just don't know what to expect about the process. So they get into a bit of overwhelm. They don't know what they don't know. They don't know what they need to prepare. But basically, they have to do very little. We're going to guide you through the whole process. So the next step is they just, it feels all a little bit hard. They're a bit exhausted about it. But once they start exploring and doing a bit of research, they realize they do need to do it. And it's not necessarily going to be that hard. And once they actually start, it can be a very proactive process. And then once we're through that process, you've got certainty, you've got control over everything, and it's something that's huge off your list of things to do. So what is that estate planning process? Well, with us, it's a 5-step process. 2 appointments. When you first contact us, we send you out some initial information so you can prepare some things. You come in for your first appointment, we guide you through that process. We get everything we need to get on that first appointment. Then you go away. We make an appointment for you in 2 weeks' time, and in the meantime, we draft the documents and we email those to you. If there is anything while we're drafting that raises questions for us, we'll ask you. If there is anything we didn't get from you in that first appointment, we'll ask you for that. Sometimes that might be a superannuation trust deed. It might be a family trust deed. It might be some information about your super that's managed by a financial planner. It might be some information from your accountant. So we get that information. So it's going to be fine. We're going to be ready for you on your second appointment so that we have everything ready for signing. So we do that on the second appointment. So that's step 4. And then after that, we deliver the plan for you. We finish it off by getting any acceptance forms signed. We submit binding nominations to super funds, and then we send you certified copies of documents and electronic copies too, if you want to provide those to a financial planner or to other family members. So then you're done. It really is that simple. It averages about 2 weeks, and you're done, protected, certain. So what does it involve? Cost is always a question, and I quite often tell people, well, you know, how much are you paying for house and contents insurance, because this process is going to cost you less than that. I do a family situation review for $450. So that's the one appointment to look at your situation to see what you need. If you need anything, even it's a review of your current situation to see if the current documents you have are fine. Now, I'm offering that for $295 at the moment. So if you ring our offices and say you've listened to my webinar, you can come in for your first appointment for $295. If you decide to proceed and do the whole process, that $295 gets rolled into the final fee, which is generally $1,100 for your basic plan for a couple, and that involves all of this. Wills, enduring powers of attorney, appointments of a medical treatment decision maker, advanced healthcare directives, instructions for guardians, superannuation binding nominations. It doesn't include testamentary trusts in your will, except unless it's a minor's trust. All right. So $295 for your first appointment to meet me and review your situation and see what you need. So I wanted to say thank you. Thanks for attending the webinar. This was a shorter one this evening, but short and sweet. Look, realistically, retirement planning is more of a financial planning endeavour, but the aspects around estate planning are important, and quite often it's people who are just about to retire, who have just retired, who come in and re-look at their estate planning. But I'd like to try and get to people before they retire and before they're trying to apply for a pension potentially, and structuring that super on retirement is also very important, as I spoke about. So my name again was Jacqui Brauman, and have a good evening. I really hope to hear from you. Stop that share screen, and I'm just going to check for questions. Right, nothing in the chat box. Okay, so it looks like everyone's understood. If there is something that you want to ask me after this session, you're quite welcome to email me, jacqui@tbalaw.com.au. But like I said, either email or call the office, $295 for your first appointment. Have a really great evening.